Good morning, ladies and gentlemen. I've been asked to address the question of Article 43.3 of the Constitution and fatal fetal abnormalities. And really that's the debate as to whether or not Article 43.3, that I know everybody is well familiar with at this stage, precludes or permits of terminations of pregnancy in cases of fatal fetal abnormality. And as we'll see, the debate really turns around what is meant by the word unborn in Article 43.3, what is meant by having due regard to the equal right to life of the mother, and what is meant by practicable. Those have been the areas of debate. I think it is perhaps important at the outset to touch upon the question of terminology that Ms. Justice Lafoy raised at the outset. The debate has generally used the phrase fatal fetal abnormality, which is a phrase that has entered into current parlance. But this debate is perhaps an unusual legal debate because it is so inextricably linked with medical issues. And as we've heard from the medics, it's difficult to say with 100% certainty that any particular condition is fatal in that a baby will not or cannot be born alive. And so there is, as part of the debate, an argument as to the appropriate terminology to use, and it's argued that life-limiting conditions is a phrase that's more legally accurate. The phrase that has also been used in the debate is the phrase a condition that is incompatible with life. And that's a phrase that we'll see in due course has been used in the recent private members' bill that was debated in the Dáil in June and July of this year, and that wasn't passed. So the background to the debate, I think, perhaps starts with the decision of the European Court of Human Rights in the case of D and Ireland. Ms. D was a lady who had become pregnant with twins. Unfortunately, at 8 weeks, she was advised that one of the twins had died, and she was subsequently informed that the other twin was suffering from a chromosomal abnormality, Edwards syndrome, that has been described by the medics. The medical evidence relied on at that stage by Ireland, by the state, was that the median survival age for a baby with that type of condition was 6 days, although there were instances of babies with this condition surviving beyond a year, but that was exceptional. Ms. D felt unable to tolerate the physical and mental toll of a further 5 months of pregnancy, and she decided to travel to the UK in 2002 for a termination of her pregnancy. She didn't bring any legal proceedings in Ireland, but subsequent to the termination of the pregnancy, she made a complaint to the European Court of Human Rights on the basis that the whole experience had been for her deeply traumatic and a stressful experience. Because it is, as the next speaker will explain, an international court, the law is that before you can bring a complaint to the European Court of Human Rights, you have to have, as the lawyers put it, exhausted your domestic remedies. So you have to have gone through the domestic legal system before you can go to the European Court of Human Rights, subject to the caveat that you're not required to go through a domestic process if it's clear that you can't succeed. And so the argument in the D case was really about this procedural issue of whether Ms. D, who hadn't brought legal proceedings in Ireland, should have brought proceedings in Ireland. And if she had brought proceedings in Ireland, was there any prospect of her succeeding in her case? And her case would have been, it was argued by the state, a case that Article 43.3 of the Constitution didn't preclude a termination in a case such as hers, where she had been diagnosed with this condition, where the evidence was the baby was, if it survived birth at all, unlikely to survive for any significant period of time. And the state argued that Ms. D couldn't make her complaint to the European Court because she hadn't brought those proceedings, and they argued that it was, as recorded in the judgment, an open question whether Article 43.3 of the Constitution precluded terminations in cases such as this. And the argument that was made was, well, before the X case, it wasn't envisaged that the X situation would be permissible. And therefore, the Irish courts did have the capacity to carve out exceptions from Article 43.3, and that was precisely what was done in the X case. And therefore, it couldn't be said that there would never be a further exception carved out from Article 43.3. And that an argument could be made that where the fetus was suffering from one of these conditions, that fetus either didn't meet the definition of unborn, or the balance between the mother and the fetus shifted so that an exception could be carved out. And therefore, the court accepted ultimately that the question of whether Article 43.3 excluded an abortion, while a novel argument, was certainly one that was capable of being argued and that the Irish courts would have treated seriously. And in those circumstances, the Court of Human Rights said, well, we can't now deal with this case because proceedings could have been brought in Ireland where this argument could have been made. That's as far as the court went. It didn't obviously deal with the merits of the case at all. But I think it's fair to say that the D case then gave rise to a debate as to whether or not it was correct that if the case had been argued before the Irish courts, the courts would have accepted that an exception existed for cases of fatal fetal abnormality. And the issue was argued out principally between legal academics, because the issue has not been required to be decided in any case to date before the courts. And there were two main sets of arguments that were advanced. The arguments for allowing abortion in the case of fatal fetal abnormality can perhaps be summarized, and this is a very short summary, as follows. First, the unborn doesn't include fetuses with no prospect of life outside the womb, and doesn't meet the definition of unborn that was subsequently put in place by the 2013 Act. Now, as I'm sure you will be aware from earlier work, the 2013 Act doesn't address the question of fatal fetal abnormalities at all. The 2013 Act was a response to another European Court of Human Rights case in A, B, and C, where the Court of Human Rights said that there should be a statutory or regime in place that allowed citizens to know and to ascertain their entitlement to a termination of pregnancy in the event that they met the X criteria. That's what the 2013 Act does, and it isn't designed to address fatal fetal abnormality at all. But the argument was made that having regard to the definition of the unborn in that Act, it was clear that it didn't encompass fetuses suffering from condition incompatible with life. Equally, the argument is made that if the fetus suffers from a condition such as this, the lives in question, being the life of the unborn and the life of the mother, are not in fact equal, because the fetus is never going to be in a position to pursue a full life, and therefore shouldn't be given the same weight as the life of the mother. And thirdly, that it simply isn't practicable to vindicate this type of life, even if the life is considered to come within the definition of unborn, or even if it's considered to be equal. So those are the three arguments that were made to the effect that abortion could be permitted. I think it's fair to say that insofar as that argument was made, it does seem to have been predicated on the assumption that there were conditions that could be said definitively not to result in a live birth. And those who were putting forward this argument, or at least some of them, acknowledged that the argument wasn't necessarily as strong when you came to a condition where the baby was born alive, and that perhaps in those circumstances, or could be born alive, in those circumstances, an amendment of the Constitution would be required. As against that argument, it's been argued that as we've touched upon, the phrase fatal fetal abnormality is a misnomer, because there's no medical certainty, even with terrible conditions such as anencephaly or Edwards syndrome, where the prospects of being born alive or of long-term survival are slim. It can't be said that the baby will not be born alive. Equally, it was argued that the definition of the unborn in the 2013 Act was simply irrelevant to this debate, where the issue is, what does unborn within the meaning of the Constitution mean? And thirdly, it was argued that the case of Roach and Roach, that I know was discussed at the previous session, the case that's referred to as the frozen embryo case, which was a case that was decided after the D case, that case suggests that Article 43.3 applies to all embryos. You may recall that was a case where the Supreme Court was required to consider whether frozen embryos came within Article 43.3 of the Constitution, and the Supreme Court held that they did not, that the protection afforded by Article 43.3 commenced after the transfer of the frozen embryo into the mother's womb, and that it was the connection between the mother and the fetus that was protected by Article 43.3, and there is language used in that decision, in particular to the effect that what is protected is the capacity to be born, that is relied upon to advance this argument that the decision in Roach and Roach means that fatal fetal abnormalities cannot be considered to be an exception or carved out of Article 43.3 of the Constitution. So those are the arguments that have been made for and the arguments that have been made against. I'm afraid I'm going through them quite quickly in view of the time available. And those various arguments have then informed some recent developments which have taken place on this topic. And you may doubtless be aware that last year there was certainly one private member's bill that was debated in Dáil Éireann. It was a bill that was presented by Deputy Claire Daly and Deputy Mick Wallace, and it was designed to amend the 2013 Act to permit of terminations in cases of fatal fetal abnormality. That bill used the phrase incompatible with life in the body of the proposed legislation. There was no definition in the bill of what incompatible with life meant or what medical conditions that phrase was thought to capture. That bill didn't pass when debated in late June and July, and it was noteworthy that the Minister for Health made a speech in the Dáil in relation to that bill, in which he made a number of significant statements. First, he said that he believed that the bill shouldn't be passed because it was unconstitutional. And the advice that had been provided to the state was clearly to the effect that Article 43.3 did preclude terminations of pregnancy in cases of fatal fetal abnormality. Although he did acknowledge that he wasn't opposed to the purpose behind the bill. The bill was presented, or debated rather, after the decision in Mellett and Ireland, which is a decision that the next speaker is going to focus on. But that was a decision which was also delivered in June of 2016, in which the United Nations Human Rights Committee upheld a complaint by Ms. Mellett, who was also a lady who travelled to the UK for a termination of pregnancy in circumstances where her baby had equally been diagnosed with a fatal fetal abnormality or a life-limiting condition. And she made a complaint to the United Nations Committee that applies or polices, if you like, the UN Covenant on Civil and Political Rights. And that committee decided in June that Ireland had breached certain provisions of the Covenant in that it had not permitted Ms. Mellett to undergo a termination of her pregnancy in this jurisdiction, and that by requiring her to travel, her fundamental rights had been breached. So by the time the bill came to be debated in the Dáil, the Minister was also addressing the outcome of the UN Rights Committee's determination in relation to the Ms. Mellett case. And the Minister indicated that he had obviously sympathy for the position in which Ms. Mellett had found herself, but didn't believe that the bill could be considered to be constitutional, in part because of the medical advice that was made available by the Chief Medical Officer. Because the Chief Medical Officer had advised the Minister that there was no medical condition that could be said 100% to be fatal, if you like. And therefore, it couldn't be said as a matter of medical certainty that a baby or a fetus would not be born alive. And if the baby could be born alive, well then the protection afforded by Article 43.3 kicked in because of the definition of unborn in case law, and in particular the definition of unborn given in the frozen embryo case of Roach and Roach. And for all of those reasons, the Minister indicated that he couldn't support the bill, and that the UN committee had been advised that a response to Ms. Mellett's case was the creation of this Citizens' Assembly, and that the Citizens' Assembly would consider the issue of the Eighth Amendment. And that is where matters now lie. In conclusion, I think it can only be said that the height of the argument made in D and Ireland that fatal fetal abnormality cases weren't captured by Article 43.3 was that it was an open question, and that was before the decision in Roach and Roach, which wasn't a fatal fetal abnormality case, but which did nonetheless address when Article 43.3 kicks in, if you like. And the state's position is that absent any determination by a court that 43.3 doesn't apply to such cases, it must be assumed that it does, and that's consistent with the purpose for which Article 43.3 was enacted, which the Supreme Court was held, was to ensure that the performing of abortions could not be decriminalised. So it seems very likely that even if a bill were to be passed by the Oireachtas, the President would refer it to the Supreme Court under Article 26 of the Constitution to ascertain its constitutionality. Clearly, the issue could be put beyond doubt by way of an amendment to the Constitution. An appropriate amendment would be required to consider, perhaps not in the wording of the amendment itself, but to address the medical issues that arise and to consider how they would be addressed and how the question of life-limiting conditions or fatal fetal abnormalities are to be considered or defined. Thank you very much.